We're here today in the state of Ohio versus Clinton Powell, case number 24CR1097. The defendant is present with counsel Deanna Robertson. We're set today for a sentencing hearing, and we were last before you on March 24th, 2025. At that time, the defendant pled guilty to improperly handling firearms in a motor vehicle, a felony of the 4th degree with a forfeiture specification. During that hearing, a pre-sentence report was ordered. That report has since been completed. The state would ask that the remaining counts of the indictment be dismissed at this time, and the defendant has 2 days of jail time credit. Thank you.
Thank you. Ms. Robertson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. My client is full-time employed and a full-time student. He's very remorseful for his actions here today. He has been responsive. He has been present at every court hearing. He's been present in my office when I've asked him to come. He is a high school graduate. He's in phlebotomy school, and I was able to get a copy of the document we spoke about in chambers. And if the court would like to see it.
Please.
Okay, may I approach?
Stand good.
Oh, okay.
I'm going to go, you can approach it. So what am I looking at here?
Those are his grades from school.
For the current school days?
Yes, it is. It shows the quizzes and the midterm grade at this point.
So you're in an internship right now?
Yes, sir.
What does that entail? Tell me what you're doing.
Right now, I'm taking my 40 sticks to make sure I can pass to...
You're taking your 40 sticks? Is that what you
40.
call when you stick someone?
Yes.
Okay.
Yes, Your Honor.
Okay. So what do you have to do for that?
I have to give a culinary, capillary, and it's the other one that's kind of hard. But
That's all right. So that's what the internship entails?
Yes, Your Honor.
Where are you doing that?
At Med-Cert.
Where?
Med-Cert. It's in Maple.
Oh, okay.
Yes, sir.
So when does this end? Probably pretty soon, huh?
After I complete my 40 sticks, and then I can take my state test.
So it should be ending within like this.
Yes, Your Honor.
This 6 month period of time here, from the beginning
Yes,
of your
Your
year.
Honor.
Then what's your plan?
My
I'll get
plan-
back to you, Ms. Roberts.
Absolutely.
I would like to retain a job from Cleveland Clinic.
Doing this type of work.
Yes, Your Honor.
And Ms. Robertson, you can continue there.
Your Honor, as you can see, he's taking his schooling seriously. He seems to be pretty good at that, which is amazing for someone like me who can't stand the sight of blood. Your Honor, I think he is a productive citizen, and I think he's learned a lot from putting his entire life in jeopardy. Not a life sentence, but just putting the small things and the larger things that he's accomplished in jeopardy by carrying a gun. We've talked about it at length, and the bottom line is, regardless of how you feel or why you feel like you have to have a gun, the law is the law, and you can't have a gun. So I've had this conversation with him. I think he finally gets it. And I do believe that if the court were to give him a community sentence without any local jail time, that it would not demean the seriousness of his offense. And I think it would be adequate to punish his behavior in this case. Thank you.
Thank you. Mr. Powell, you have a right excuse me, to address the court and say whatever you want me to know or consider. Is there anything you want to say at this time?
Yes, Your Honor.
Go ahead.
I would like to apologize for putting the people that I was with and the officer that arrested me in jeopardy.
Jeopardy?
In jeopardy, yes. I understand the laws a little bit more. I wasn't clear with the laws at first, but now I understand that riding with a gun is not the safest thing to do, or but under the circumstances that I am in, it is not the proper way to go about things.
What was the prior incidents about? That's the only concerning part I have here, is that it's not your first time in court regarding a firearm. So how did the lights go on then, or the knowledge gained then? How did that happen? There's 2 other incidents, right?
Yes, Your Honor.
I know they were all wrapped up at the same time, because they all happened right around the same time, it sounds like.
Then I wasn't taking stuff seriously. Now I have things I'm trying to accomplish, and I just got
Because your lawyer says, comes in and says, the lights have gone on or something to that effect. She said, I can't remember exact words. And I'm saying, well, why didn't the lights go on last time when you were in court? You were on probation for this, which you completed. I see that. But nonetheless, you were, on probation previously for carrying a concealed weapon 2 separate times within a couple weeks of each other, it sounds like, almost. 2 or 3 weeks of each other. You went out, you were on probation, you completed that, and you get off probation, and then this happens.
The weapon was placed in the glove box by me, but I do not own the gun.
I understand. Why do you think you need to have a gun?
I don't.
I interrupted you. Is there anything else you'd like? I want you to finish what you wanted to say, if there's anything else you wanted to say.
I just want to apologize to the court and everyone else that I put in jeopardy, and I wanted to ask for a little bit of leniency if there is some. And I understand I will abide by every court rules and everything that the court asks me to do.
Well, let me tell you something off the beginning here. If you're put on probation, this isn't Cuyahoga County out here. And I know you have experience there. Maybe you know people that have gone through probation there. This is more strict, and you're going to be responsible for being accountable for the conditions that get imposed. And there's going to be conditions out there. There's probably just call your probation officer once a month.
No, we have conditions, Your Honor.
You're going to be held accountable to them, and if you mess up, you're going to go to jail or prison. It's easy as that. That will happen, I can guarantee you that. You'll at a minimum be getting locked up immediately if you screw up. You understand that?
I understand, Your Honor.
What's the status of your driver's license? I know it's suspended,
It's suspended.
But why, and what do you need to do to...
I have to go to Bedford in South Euclid. I scheduled my Bedford court. It should be May 7th.
Well, that was my next question. So why did you skip court?
I have no reason, because I couldn't make it there because I wasn't the driver.
That's not going to be an excuse out here. If you're required to report, you have to report. If you don't show up, it doesn't matter any excuse. Any excuse. You're going to be a warrant issue for you.
I understand, Your Honor.
And it's going to be worked on. You're going to get arrested on. It's not just going to be some traffic warrant that sits out there and nothing happens to it. You get it?
Yes, Your Honor.
There's 2 cases here. One in South Euclid that you missed also.
Bedford and South Euclid. I just rescheduled for Bedford, May 7th.
You had court in South Euclid March 4th that you didn't go to.
I have to reschedule that one.
Yeah, there's a warrant out for you. Why didn't you go to court?
I didn't have the funds and I didn't have a way there.
You have a way there. You do whatever you need to do to get there. I don't get the thought process where I'll just skip court, and let them issue a warrant for me because I can't get there. You leave the night before and walk there if you got to walk there. Do whatever you need to do to get there. You've been here every time we've had to be here. You weren't taking it serious. So tell me what you got to do. I know I interrupted you. Tell me what you have to do to get your license.
I have to pay Shaker the rest of the money that I owe them.
Which is about what?
$350. I owe them $500, so I paid it down. I'm paying them. I have to pay Bedford and South Euclid and get to pay about $45 in bench warrants to the BMV and get a couple release forms from Bedford and South Euclid.
When did you last have a license?
I believe last year.
Life easier when you have a license?
My license was,
He said,
Well, go ahead. What were you going to tell me?
I was going to say, it says, 2024.
So is it expired?
Yes,
So you need to get a new license.
yes, Your Honor.
but the judge asked you, is it easier?
Isn't life easier when you had a license?
Yes, Your Honor. Sorry.
Your Honor, if I may. He was correct with the different courts that he has to address. He owes $95 to the BMV. His license is not expired. It won't expire until October of 2027. So he won't have to retest, as long as he obviously gets all those things done within that time.
Then what he's got is valid. What were you looking at then?
It's a
This
suspended
is a
license.
suspended license.
He does have a license that's suspended. It's not like it expired and he has to retest.
Right, that's what I was concerned about. So if he takes care of that stuff, he's got a license.
He does,
Yes,
He doesn't have to worry about taking it to the test.
correct.
All right. Anything else, Mr. Powell, you would like to say?
No, Your Honor.
All right, Ms. Robertson, anything else?
No, Your
All
Honor,
right,
thank you.
can be seated, thank you.
Okay.
Ms. Belford, State of Ohio?
Thank you, Your Honor. I had the opportunity to review the pre-sentence report in this case, and the defendant has a criminal history. It seems all concentrated in 2021, and it's not the worst I've ever seen.
Seems all concentrated within like a month.
Yeah. And this young man has more going for him than most of the defendants that I have in my caseload. He clearly takes pride in his schoolwork. So just based on all that, the state would ask for a community control sanction in this case. Thank you.
So yeah, what was going on? So between April of 21 and December of 21 is your whole criminal history. About 6 months. What was going on then? I mean, you got some serious stuff there,
Yes, Your
but
Honor.
it's within a 7-month period of time.
I just wasn't taking things serious as I should have been. I was just being a foolish kid back then. And now I just came to reality of life. Not just now, but in that time as I completed my probation and the courses that they sent me to do.
All right, you can be seated, thanks. I have considered the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by Ms. Robertson on behalf of her client, the defendant himself, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes this offense. As for recidivism factors, the court finds the defendant does have prior criminal history, as I just alluded to. I mean, there are 4 4 felony charges, all again within March of 21 to December of 21. That's the extent of his history. He has some traffic stuff in which, again, warrants have been issued for him for not showing up when he was supposed to. Number 29, under the factors indicating recidivism is less likely, the court notes there appears to be genuine remorse. Obviously, initially there was some difficulty with the officers at the original stop, but since then he's been cooperative, he's acknowledged what he did, there's been genuine remorse. Under 29-13B1, the court finds the offense involves the possession of a firearm, which overrides any presumption for community control. However, the court finds community control is consistent with the purposes and principles of sentencing. Prison is not, and the defendant is amenable to available community control sanctions. So I'm going to place you on community control sanctions for a period of 2 years. In order that you serve 2 days in jail with 2 days of credit. So I'm not ordering any more jail time right now. But if you don't comply with any of these conditions, you'll immediately be going to jail. And there's not going to be any arguing about that. And it's not going to be any valid excuses, quite frankly. You understand that?
Yeah, sure, Honor.
All right, so 2 days in jail with 2 days of credit. I'm going to order that you not use any drugs or alcohol. That means no marijuana use. And I know you were using marijuana. You stopped when this happened, and it appears that you have. I mean, you were tested clean when tested. But you're not allowed to use marijuana either. So no drugs or alcohol, including marijuana. I want you to obtain and maintain either full-time employment, full-time education, or a combination of the two like you're doing now. But on a full-time basis, I want you either working, going to school, or some combination of the two that keeps yourself busy in a full-time. Understand that?
Yeah, sure, Honor.
How do you get around now? Like to go to school, go to work, do what you need to do?
I Uber and my girlfriend back there text me to work.
How are you going to report to probation when you have to report?
She's okay with bringing me, like she did today.
Well, I want you to do 2 things. One, immediately take care of these warrants. Now, it sounds like you may have something planned, at least in one court.
Yes.
You need to immediately take care of these warrants. I can't have you on probation with warrants out there for you. So whatever happens, happens, and that's not going to be held against you in terms of my probation. And it would, if you plead guilty to charges, that's not going to affect your probation here. I'm not telling you you have to do that. You can fight it if you want, but whatever you do is in your best interest. It's not going to impact your probation unless you don't do anything. If you don't take care of it, then that'll impact your probation. Take care of that, because once you take care of that, then you can address your license, and I want you to obtain your driver's license. I'm also going to order that you complete our decision points program. When do you think you're going to be able to have your license? Realistically.
Realistically,
I'm not holding you to this date, but I want to get an idea.
in about the end of July.
Okay. Well, once you get your driver's license, I want you to then complete this decision points program. I'll let you wait until you get that because you have to come out here once a week for that. Maybe you're able to do that, but I'm not going to put that on your girlfriend. It's not her responsibility. And if you can get it by end of July, in the beginning of the fall sometime, again, I'm not holding you to July, so you're not going to be violated if you don't have your license by July, but you need to do what you need to do to get it.
Absolutely.
Once you get that, I want you to enter and complete this decision points program. That's just you're not in jail or anything. It's a program you go to. It helps you with your decision making and thinking. It's a good program. I'm also going to order that you perform over the 2 years 50 hours of community service, pay your court costs and supervision fees. I'm going to order the forfeiture of the whatever contraband instrumentalities, probably the firearm, and whatever else was there with it. I'll dismiss the remaining counts of the indictment as agreed to. Not to possess any firearms.
Yeah, sure.
Doesn't even just mean own, you can't possess. So it doesn't matter if it's yours or not. You understand that?
Yes, Your Honor.
That's only not a probation violation, that's another felony you're gonna get if you do that. So. Jennifer, anything else I should be considering here or you recommend?
No, thank you, Your Honor.
So Mr. Powell, you understand all the conditions of your probation?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
Okay, I'm giving you a chance here. I mean, it's pretty rare that somebody walks out of here at sentencing without any jail time, to be honest with you. I'm giving you a chance. Take advantage of it. I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime from this point forward while you're on probation. So again, handle those other cases that are pending however you need to in your best interest. I don't care about those. But if you commit some new crime going forward, if anything like that happens, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it would be 18 months in prison, so that's what's hanging over your head. You understand that?
Yes, Your Honor.
I'll also order the release of bond at this time. All right, Ms. Bell, anything else for the record?
Nothing further, Your Honor. Thank you.
Ms. Robertson?
No, Your Honor, thank you.
Stand up. All right, thank you. Good luck.
All rise. 1, along with the forfeiture specification. It is the state's understanding that today the defendant would like to withdraw her previously entered plea of not guilty and plead guilty to this one count, and there is no agreement as to sentencing.
Thank you. Mr. Fatigue, does that sound accurate?
Good morning, Your Honor. That does sound accurate. Thank you.
And Mr. Accuso, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this morning?
Yes, Your Honor.
They indicated to court they believe it's your desire to withdraw your previously entered plea of not guilty to count 1 of this indictment. I'll go over that with you to make sure you understand what that involves, and plead guilty to that charge, and then the other counts would get dismissed. We would
Yes.
then defer sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as other possible penalties that you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you?
I am 40 years old.
Are you able to read and write the English language?
Yes, I am, Your
Do you have
Honor.
any difficulty with that or difficulty understanding what you read in the English language?
No, I do not, Your
Are
Honor.
you a U.S. citizen?
Yes, I am.
Now, before you came into court here today, have you any drugs or alcohol of any kind?
No, I am not, Your Honor.
What about within the last 48 hours?
No, I have not, Your Honor.
Not even prescribed medication, nothing?
Prescribed medication, yes.
Okay, what have you had in regards to prescribed medication within the last couple of days?
Cymbalta and Abilify and omeprazole.
What was the last one you said?
Omeprazole, it's for heartburn.
Oh, okay. Now, do any of those medications affect your ability to understand or appreciate where you are, what's going on around you, or anything like that?
I do not believe so, Your Honor.
Okay. So you're not under the influence of these medications right now in any manner that's negatively impacting you?
No, Your Honor.
Now, you would have received a copy of this indictment sometime, not that long ago, about a month ago, a little over a month ago, in the middle of March. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, yes, I do.
Did you have a chance to look that over at some point?
Yes, I have, Your Honor.
Now, in that indictment, you're charged with 4 counts. You're pleading guilty to 1 count, count 1. And what's alleged in this first count and what you'll be admitting to is on or about December 6, 2024, in Willoughby Hills, Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount of the cocaine did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes, I am, Your Honor.
Any questions about it?
No, not at all, Your Honor.
Now, the charge also carries with it what we call forfeiture specification, which alleges during the commission of the offense you possessed or had some interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the product itself. Whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner, or it's being used to facilitate a crime. You can't possess it in that way for that purpose. And here it's specifically alleged that there was the cocaine along with a fentanyl-related compound, a glass pipe, and a spoon. And the whole point of this is that you forfeit any interest you have in that property. Do you understand that?
Yes, I do, Your
Any
Honor.
questions about it?
No, I do not.
So you understand the nature of the offense you're pleading guilty to?
Yes, I do, Your Honor.
Now, there are 3 other counts of this indictment. Those are all being dismissed pursuant to the agreement. Is that your understanding?
Yes, it is, Your
You
Honor.
have any questions about those 3 charges?
No, there isn't.
Well, then, before I can accept your guilty plea to the count that I just read to you, count 1, I need to make sure you understand all the rights you're giving up. And you, first of all, have a right to have a trial. Now, that trial could be to me as a judge, where I listen to the evidence, and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty as to each charge. Do you understand that?
Yes, I do, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial in this case?
Yes, I do, Your Honor.
Now, if you did have a trial in this case, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, with her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you can be found guilty. You're presumed innocent of this charge, and that presumption of innocence will stick with you and remain with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, I do, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that's the highest burden of proof there is in our justice system. What it actually means, it's the amount of the evidence, the quality of that evidence that the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of that charge beyond any reasonable doubt before you could ever be found guilty of that charge. Understand that?
Yes, I do, Your
You
Honor.
understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, I do, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state, and they would answer questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, I do, Your
Do you
Honor.
understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, I do, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have the right to do that if you wanted. Do you understand that?
Yes, I do, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if that person wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, I do, Your Honor.
Do you realize you're giving up that right?
Yes, I do, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you and you alone would have to make. Do you understand that?
Yes, I do, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, I do, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, I do, Your Honor.
All right, well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do, Your Honor.
Do you still want to plead guilty?
Yes, I do, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? That means you're admitting to the facts being alleged by the prosecutor regarding this count one. We're not going to argue you didn't commit this offense or it's someone else's fault or anything like that. Do you understand that?
Yes, I do, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, I do, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to one count of felony of the 5th degree. This particular offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, I do, Your Honor.
Now, are you currently on probation or parole or supervision in any other courts or agencies?
No, you're not.
No, not that I know of, Your Honor.
Sorry?
No, Your Honor.
Do you have any other criminal charges pending against you anywhere?
No, Your Honor.
Now, if a prison sentence were imposed in this case, upon your release from prison, you could be placed on what we refer to as post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. In this particular case, it could be up to 2 years. Do you understand that?
Yes, I do, Your Honor.
And if you found yourself on post-release control and ever violated any of the conditions of your supervision, the parole authority could return you to prison, send you back to prison as punishment for violating the rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of what other prison term was imposed by the court. Do you understand that?
Yes, I do understand, Your Honor.
All right, now aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $2,500. Excuse me. You could also be ordered to pay court costs. I could also order that you reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, I do, Your Honor.
There's also a possible driver's license suspension that I could order of up to 5 years. Do you understand that?
Yes, I do, Your Honor.
And as I alluded to earlier, any right, title, or interest you have in the property that's in that forfeiture specification will be forfeited in the state of Ohio at the time of sentencing. You understand that?
Yes, I do, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not mandatory with this charge. You are eligible for probation or what we refer to as community control sanctions. Do you understand that?
Yes, I do, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're going to be requesting. I'll look at all the information that gets presented to the court. Then I'll make the decision that I think overall is the right thing to do. Do you understand that?
Yes, I do, Your Honor.
Now, if you are put on probation at any point, it could be for up to 5 years of supervision. As the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, I do, Your Honor.
Further, if you are on probation to this court at any point and you violate any of the conditions of your probation or the rules of probation, we will have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend the probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that at that point, again, it could be anywhere from 6 to 12 months in prison, and that could be consecutive to any other new case that you may pick up or you're being sentenced to or that you're serving at that time. You understand that?
Yes, I do, Your Honor.
All right, well, do you have any questions at all? We'll strike that. And the last thing I want to make sure I advise you of. Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want. Anything you'd like me to know or consider, your lawyer's allowed to speak on your behalf, and he can recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, I do, Your Honor.
Now, do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, I do, Your Honor.
All right, well, do you have any questions at all about the possible penalties you face by pleading guilty?
No, there isn't, Your Honor.
Do you understand all the possible consequences that could occur?
Yes, I do, Your Honor.
Do you still want to plead guilty?
Yes, I do, Your Honor.
Have you had enough time to talk about this case with your lawyer and have him review the reports with you, discuss the issues, and answer whatever questions you may have?
Absolutely, Your Honor.
Are you satisfied with his advice and counsel?
Yes, I am, Your Honor.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
Absolutely not, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
Absolutely not, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, I am, Your Honor.
All right, then. Any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, I understand completely, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with the actual plea?
No, I don't, Your Honor. Thank you.
So what's going to happen at this point, then the prosecutor here is going to explain for me what she believes the evidence in this case would show if we had a trial. I want you to listen to what she says, because then I will have some follow-up questions for you, okay?
Yes, Your Honor.
School?
Thank you, Your Honor. The facts would show that on December 6, 2024, in Willoughby Hills, Lake County, Ohio, officers conducted a traffic stop on a vehicle that the defendant was driving and gained probable cause to search the car. During the search of that vehicle, officers located suspected cocaine, which was sent to the Lake County Crime Lab and determined to be less than 5 grams of cocaine, a Schedule II controlled substance.
Thank you. So, Ms. Syracuse, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we did have a trial?
Yes, I have, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, I did, Your Honor.
Very well, then, regarding count 1, charging with possession of cocaine, a felony of the 5th degree, along with the forfeiture specification, what is your plea to that at this time?
Guilty, Your Honor.
All right, I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over this with your lawyer. Is that correct?
That's correct, Your Honor.
Mr. Fatika, is that accurate? Did you review this with your client, have her go over everything with her?
Yes, Your Honor.
Did she indicate an understanding of it to you when you did that?
She did.
Is that correct, Ms. Syracuse?
Yes, I am.
So you understand what the document says?
Yes, I do, Your Honor.
Do you have any questions for me about what it says?
No, I do not, Your Honor.
It also appears that you signed this document on the top of the last page. Did you in fact sign it?
Yes, I did, Your Honor.
Mr. Fatika, you witnessed that?
Yes, Your Honor.
You as well, Ms. Gold?
Yes, Your Honor.
Was I supposed to stand up?
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree, in violation of 292511 of the revised code, the forfeiture specification. Counts 2, 3, and 4 will get dismissed at sentencing, but I will continue sentencing, order a pre-sentence report and investigation, and a drug and alcohol evaluation. Bond will remain revoked. Mrs. Gold, anything else for the record?
No, Your Honor.
Mr. Fatika,
No, thank you, Your Honor.
thank you.
All rise.
had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain that in more detail here, what that actually means, and then plead guilty to the charge and the information, which I will also go over with you to make sure you understand that. We would then defer sentencing to order and order some reports to be completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today?
Yes, Your Honor.
Well, before this court can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
I'm 31, Your Honor.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Excuse me for 1 second. Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
I take insulin for my diabetes.
Okay. I assume that does not affect your ability to understand or appreciate where you are, what's going on, your surroundings, anything like that, does
No,
it?
Your Honor. Not at all.
Anything else?
No.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing?
Yes, Your Honor.
And did you have the chance to review that at some point?
Yes.
Now, in that information, you're charged with one count, and what's alleged here and what you're admitting to is on or between June 2nd, 2023 and August 22nd of 2024 in Willowick, Lake County, Ohio, that you did with purpose to defraud or knowing you were facilitating a fraud, present to or cause to be presented to Liberty Mutual Insurance Company, who is an insurer, a written or oral statement that is part of or in support of an application for insurance or a claim for payment pursuant to a policy or a claim for a benefit pursuant to a policy, knowing that the statement you provided or any part of that statement was false or deceptive. It's further alleged that the amount of the claim that was false or deceptive is $1,000 or more and less than $7,500, which makes the offense insurance fraud a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand I need to make sure you understand all the rights you are giving up by pleading guilty. And you, first of all, have the right to have this case presented to a grand jury. So that document that I just read to you that I referred to as an information is a charge that's brought by the prosecutor without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. You know, this bond paperwork's all screwed up. We have, like, his signature is on the top of the OR bond form. His signature for the conditions of bond form are on the top of the OR bond form. Let me see his, Mr. Petit's.
I have a blank copy.
The conditions of bond form only has the defendant's signature. The signature block for Mr. Patika is then on the top of the owner Cogson's bond form. It's missing his signature block, and then it's up here on the top of, so it's not like he even
Yeah, I don't know.
signed the conditions bond for him.
I didn't hand this to defense counsel today, so it's probably printing.
Well, how'd he get it?
I emailed it to him, so I'm assuming it printed this way, but I handed him.
It will take us 2 minutes to redo it.
I don't know how that happened.
And we'll do that afterward. Where was I, Mary? Talking about the... Okay. All right, so I was talking about the grand jury process, Mr. Cook, and the grand jury is... It's made up of a group of citizens that listen to evidence and make a decision whether probable cause exists that someone committed a crime. Probable cause is some evidence that suggests the person probably committed a criminal offense. Everyone in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not, and you have that right as well. But you can give up that right if you desire, go forward on the charge brought by the prosecutor and the information. And again, your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Before I can go further, I need to have you acknowledge that here in open court, in writing, and I have in my hand here a document, one-page document called a waiver of indictment, which sets forth everything I've just talked about with you regarding this grand jury process and indicate you want to give up that right. Before I can go any further, I need to be assured you understand the document and that you sign it here in court. Now, my understanding is before I came in here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review this with Mr. Cook and answer all his questions?
Yes, Your Honor,
Did he indicate an understanding of it to you when you did that?
he did.
Is that correct, Mr. Cook?
Yes, Your Honor.
So you understand this document, what it says?
Yes, Your
Do you
Honor.
have any questions for me about it?
No, Your Honor.
Now, it also appears that you signed the document. Did you in fact sign it?
Yes, Your Honor.
Mr. Fatika, did you witness that?
I did, Your Honor.
Mr. Gretzky, you as well?
Yes, Your Honor.
Very well, then I will make this document part of the record. At this point, Mr. Cook, I'm going to go over with you all the other rights you have that you're giving up by pleading guilty, and you first of all have a right to a trial. And that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of the charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job where she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of the charge, and that presumption of innocence sticks with you and it stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we talk about this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state has to present at a trial to prove you guilty. So in this case, they would have to present evidence to prove each element or part of the charge beyond any reasonable doubt before you could ever be found guilty of the charge. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to try to do that, if we did have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state. They'd be answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. He would be permitted to ask them anything he wanted to within certain rules. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have the right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you by answering your lawyer's questions. If that person didn't want to come in voluntarily on their own, do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you would also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision, that is a choice that you and you alone would have to make. Do you understand that?
Yes, Your Honor.
So what that actually means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court. Then you will subsequently, on another day, future date, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to one count. It's a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole with any other courts or agency?
No, Your Honor.
Agencies, I should say. Do you have any other charges pending against you in any court?
No, Your Honor.
If a prison sentence were imposed at any point in this case, upon your release from prison, you could be placed on what we refer to as post-release control. It's sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you were violating the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined, in this case, up to $2,500. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the criminal conduct. Do you understand that?
Yes, Your Honor.
Give me 1 second, please. Now, a few moments ago I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory in this case. You are eligible for probation, or what we refer to as community control sanctions. You understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you'll automatically be put on probation. It means I'll consider that. And I'll look at all the information presented. Then I'll make the decision I think is the right thing to do. You understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be up to 5 years of supervision, and Hang on one second. We have up to 5 years of probation, and as a judge, I had the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. So just because if you were to get probation, that doesn't automatically mean there's no incarceration. There could still be local incarceration in our county jail for up to 6 months as a condition of your community control. Do you understand that?
Yes, Your Honor.
And further, if you are in community control and you ever violate any of the conditions of your community control, we would have a hearing to see if you're what's called a probation violator. If it's determined that you were, I could extend your probation up to 5 years if it wasn't already 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison at that point. And again, that could be anywhere from 6 to 12 months, and it could be consecutive to any other prison sentence that you could be serving at that time for some other case, or that you may be getting sentenced to at that time for a new case. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend a sentence to the court. The prosecutor here can also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, that's just what it is. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the possible penalties you face by pleading guilty here?
No, Your Honor.
You understand all the possible consequences that could occur at the time of sentencing?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with Mr. Fatika and have him go over everything with you, answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty here today?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
Any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your actual plea?
No, Your Honor.
All right, then what's going to happen at this time is the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to what she says, because then I'm going to have some follow-up questions for you, all right?
Okay. Yes, Your Honor.
All right, Mr. Gretzky?
Your Honor, the defendant, Anthony Cook, lived with his wife at the time, Shanae Cook, at 384 East 324th Street, Wilwick, Lake County, Ohio, on June 2nd of 2023, when the two of them submitted a claim for a benefit from a policy they had with Liberty Mutual. The claim they were making involved personal property allegedly being stolen from a vehicle that they left in their driveway in Willowick. They submitted an itemized list of what the items that they were making a claim for. The defendant also made a police report. Both the defendant and his wife at the time were interviewed. They gave inconsistent stories in their interviews as to what happened. They also provided documentation to Liberty Mutual in the form of screenshots of purchases or receipts of purchases from Best Buy. However, there was no records of these items being bought on the days that those receipts claimed. In some instances, even the amounts were wrong. And in fact, the records showed that several of the items have been returned after being purchased on different days than what those receipts claimed, therefore showing that the receipts submitted by the defendant and co-defendant were forged. The amount that they were making a claim for was over $1,000 and less than $7,500.
Have both been charged or just the one?
They've both been charged.
Mr. Cook, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do as she said?
Yes, Your Honor.
Very well, then, regarding count one, charging you with insurance fraud, a felony of the 5th degree. What is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and you sign it here in open court. What is that?
It's not always, sir.
Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Fatika, is that accurate? Did you review that with Mr. Cook and answer his questions?
Yes, Your Honor.
Did he indicate an understanding of that document to you?
He did.
Is that correct, Mr. Cook?
Yes, Your Honor.
You understand what the document says?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
Now, it appears that you signed the document. Did you in fact sign it?
Yes, Your Honor.
And Mr. Fatika, you witnessed that?
Yes, Your Honor.
Mr. Grisky, you as well?
Yes, Your Honor.
Very well, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, insurance fraud, a felony of the 5th degree in violation of revised code section 2913.47B1. The first sentencing, order of pre-sentence report and investigation, victim impact statement. Any other issues that you want to explore, Mr. Fatika?
No, thank you, Your Honor.
I will set the defendant's bond at his own cognizance with the condition that he have no contact with Liberty Mutual. So what all this means, Mr. Cook, in continuing the bond that was set in municipal court, so there's nothing more you need to do. You'll sign the form, your signature is your bond. But I need to advise you that you need to appear at all future court dates. If you fail to appear at any future court date when you're released on an owner cognizance bond, that's a separate felony you could be prosecuted for, which is actually more serious than what you just pled guilty to. You can get up to 18 months in prison. So it's obviously important you show up at all future court dates. You understand that?
Yes, Your Honor.
Stan, when's the sentencing?
Sentencing will be 6/16 at 1:30, sir.
So your sentencing is June 16th at 1:30. So that's your next court date. So that's the date that you need to make sure you're here for pursuant to your bond. You understand that?
Yes, Your Honor.
Now, prior to that, though, there's going to be some other stuff that's going on. I've ordered a pre-sentence report. That's a report the probation department puts together for my benefit, give me information about you and your background. The way they get that information is they're going to conduct interview with you. It's very important that when you meet with them and speak with them that you're open and honest with them, because they check and verify what you tell them. And if they learn you're misleading them in any way, they'll let me know that, and I would consider that obviously as sentencing. You understand that?
Yes, Your Honor.
One of the conditions of your bond also is that you don't use any drugs, which includes no marijuana use. If they request urine screens, you must provide them. If they should come back positive, your bond would be revoked and a warrant would be issued. Do you understand that?
Yes, Your Honor.
Lastly, that pre-sentence report must be completed before this court can even consider probation as an option. Without a pre-sentence report, the law doesn't allow me to consider probation. So it's important that you show up at the probation department on time when scheduled for that interview, which will obviously be before the sentencing day. Because if you don't show up there, cooperate with them, then they can't do a report. And without a report, I can't consider probation as an option. You understand that?
Yes, Your Honor.
All right. So you're going to leave here now. You're going to go over to the probation department. You're going to fill out some initial paperwork and get your date to come back for that interview. So make sure you go there when you leave here, right immediately after this, all right?
Yes, Your Honor.
All right. Mr. Fatika, anything else that we need to talk about?
No, thank you, Your Honor.
Mr. Gritsky?
Nothing further.
All right, thank you all.
We're here in the matter of the state of Ohio versus Javier Herrera. This is case 25 CR 239. Mr. Herrera is present in court. He is accompanied by his attorney, Ms. Nicole Novotny. He was last before the court on the 3rd of April, where he entered a plea of guilty to an information charging him with 1 count of attempted felonious assault, a felony of the 3rd degree, 1 count of vandalism, a felony of the 5th degree, and a misdemeanor count of aggravated menacing. At the time of the plea, the court ordered a pre-sentence investigation along with victim impact statement, mental health evaluation. Those having been accomplished and delivered, we're here today for sentencing.
Thank you. Ms. Novotny, any reason not to go forward with sentencing?
No, Your Honor, we may proceed.
Anything you want to say on behalf of your client?
Yes, Your Honor. We are just asking for any type of leniency with regard to this matter and to sentencing, Your Honor. Ultimately, after talking with Mr. Herrera throughout this case, he does show regret for his actions and know he should have handled the situation a little bit differently than what had occurred. I know after this incident, he understands that he needs some sort of anger management with regard to it and how to express himself when he's angry with something. Ultimately, Your Honor, he was born in Mexico and he moved to the United States when he was 16 years old. I know throughout the proceedings here, my office has been in touch with an immigration attorney regarding his current status and situation. I know he obtained his permanent residency in 1986, but given the gravity of such charges and conviction he'll face, most likely removal hearings with regard to that, so he's fully aware of his rights and what could occur regarding that status. Throughout his life, Your Honor, he has worked in construction as a union laborer throughout Indiana and Illinois. He has significant ties to Illinois, Your Honor, as he resides there currently with his sister. He's been living with her for quite some time. Ultimately, he does have 2 adult children, Your Honor. He's currently 69 years old and retired and gets a pension for his payment monthly. I know for the purposes of him being in Ohio, he was visiting a friend who was experiencing strokes and came to visit him, and I was also looking to obtain a vehicle from him as well. We're just asking for any leniency when it comes to this matter, Your Honor, in front of you today.
Thank you. Mr. Herrera, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say?
I'm fine, Your Honor.
You're fine?
Yes.
Ms. Novotny, anything else?
No, Your Honor.
Ms. Mulligan?
Your Honor, this is the state's position that a prison term is warranted in this offense of violence.
Thank you. This court did review the pre-sentence report and evaluation along with the psychological evaluation. I consider the facts and circumstances of this offense, the nature of the offense. Consider what's been said here today by Ms. Novotny, the prosecutor. The defendant was afforded an opportunity to address the court, chose not to make a statement, which is fine, doesn't need to do that. This is considered, I also received 2 victim impact statements in this case, and I've reviewed those. This is considered by the court in light of the purposes and principles of felony sentencing, set forth in 292911 of the revised code. As for factors indicating the conduct is more serious, court notes that the victims here suffered, frankly, psychological harm as a result of this. There's physical harm as well. I would say it's serious physical harm, but certainly psychological harm. Just completely unwarranted, unprovoked. Also appears as a factor making it more serious that it was motivated by prejudice based on race, ethnicity, gender, race and ethnicity, I should say. No factors indicate it's less serious. As for factors indicating recidivism is more likely, court notes the defendant has a lengthy history of criminal convictions, and it goes back 50 years. Now, it's not every year. It's not. There are certainly gaps in that period of time, so I don't want to make it sound like it's 50 years where this was constant criminal offenses, but the original offense goes back 50 years, and there were multiple criminal convictions. He's previously served a prison term. He committed this while he was on bond for an OVI offense that's currently still pending because there's a warrant out for him for his failure to appear for this hearing back in 2020. Not responding favorably to previously imposed sanctions. There's no genuine remorse at all. No factors indicate recidivism is less likely. Count 1 is a felony of the 3rd degree, which doesn't carry any presumptions one way or the other. Defendants previously served a prison term as well. In considering all the foregoing, this conduct is not just an offense of violence, but a serious offense of violence. Completely unwarranted. I don't get it. I don't believe your story in regards to, they just started calling me names out of the blue, so that's why I did it. The victim's version is clearly much more credible, that you went up to them asking them for money. And at that point, maybe they said some words to you that you didn't like. But words, these are lessons we teach our kids in 1st and 2nd grade. You get called names. You don't take a metal bat or metal rod and just start beating them, breaking their property and beating them. That's exactly what you did here. Your conduct doesn't warrant leniency. You got leniency with the plea that was made because ultimately what you pled to was less serious than what you actually did here. But the conduct involved here is extremely serious, it's extremely violent. Imprisonment is consistent with the purposes and principles of the sentence, and community control sanctions is certainly not warranted with this conduct. The defendant is not amenable to community control sanctions. Therefore, it's a sentence of this court that on count 1, charge of attempted felonious assault, defendant served a term in prison of 18 months. Count 2, he served a term in prison of 10 months. Those would be concurrent. And then aggravated menacing, I'll order 180 days, which is by law concurrent. He has credit for 64 days. I need to advise you upon your release from prison, post-release control in this case is mandatory for at least 1 year. It could be a maximum of 3 years. If you're on post-release control and violating the conditions of your post-release control, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. I'm also going to order restitution to the victim, Hector Rodriguez Ibarra, in the amount of $800 for the damage to the windows. That's for the cost of replacing the windows to the van that were all broken by the defendant's conduct. I think that covers everything, Ms. Mulligan. Is there anything I'm missing or need to address?
I don't think so.
Ms. Novotny?
Nothing further, Your Honor.
We're here in the matter of the State of Ohio versus Tanika M. Woods. This is case 24 CR 1191. Ms. Woods is present in court. She is accompanied by her attorney, Ms. Rachel Smith. She was last before the court on March 24th, where she entered a plea of guilty to 1 count of aggravated assault, a felony of the 4th degree. At the time of the plea, the court ordered a pre-sentence investigation report along with victim impact statement and a drug and alcohol evaluation. Those having been afforded the opportunity to be completed, we are here today for sentencing.
Thank you. Mr. Smith, any reason not to go forward with sentencing?
Thank you, Your Honor. We would be moving for a continuance today. There is not a completed pre-sentence report in this matter because Ms. Woods did not appear for a pre-sentence interview. Outside of the lack of a pre-sentence report, however, Ms. Woods did plead guilty via information to a felony of the 4th degree, which is probationable. Based on her criminal history and other factors, she would otherwise be amenable to probation. Her bond was previously revoked following change of plea for a positive marijuana screen. She did disclose to the court prior to, during that hearing, that she would be positive for marijuana. She did not take the court's admonition lightly following change of plea. She did not smoke or drink at all between the change of plea and today's sentencing date. That is supported, at least as to the marijuana, because when she self-surrendered last night, her test was negative. While in bond, there were no additional new criminal issues, and her last criminal offense is from 2002. She's never been to prison. So we are asking the court to grant a continuance to keep her bond revoked and have her stay in the Lake County Jail to allow for a pre-sentence report to be completed.
Well, I'm denying that request. She was advised when she was here last time that I ordered a pre-sentence report for her to give her the opportunity to seek probation. She was advised that if she failed to appear for that interview, that a pre-sentence report couldn't be completed, and without a report being completed, I'm not able to consider probation as an option. I told her that, and she chose not to show up. She turned herself in yesterday, 24 hours ago. It's the first time she showed up. And she knew what the consequences were, and she made that decision herself. She made that choice knowing what the consequences were. So we're going forward with sentencing today, and your request is denied. So is there anything you'd like to say on behalf of your client?
Yes, Your Honor. On behalf of Ms. Woods, and at the risk of repeating some of the arguments we just provided in support of a motion to continue, Your Honor, we would ask the court to impose a minimum prison term here, understanding that the only thing available to the court to impose is a prison term without the pre-sentence report. We would otherwise be asking for community control. Ms. Woods is employed. She works for a clothing manufacturer. She has 4 kids. All of them are grown now. She also has 6 grandchildren. 2 of her sons are in the courtroom today and would like the opportunity to address the court in support of her when appropriate. She has no criminal history since 2002, no history of offenses of violence, has never been to prison, and in the past, when she was placed on community control, she did successfully complete community control. During the pendency of this matter, she was on bond without any new criminal issues, although she did forget the restriction that she not smoke marijuana following the reminder from the court at change of plea. She did cease smoking and drinking. She also has been diagnosed with anxiety, depression, and post-traumatic stress disorder. And with those things in mind, we would ask the court to impose a minimum prison term in this case.
We can hear from the folks that would like to speak on her behalf at this point. Whoever it is that would like to address the court, you could just stand right where it is that you're seated, state your full name, spell your last name for the court reporter, and then say whatever you'd like me to know. Anybody?
Good morning. My name is White, W-H-I-T-E.
Thank you.
Honestly, I want to start off by saying my mom is no monster. You know, she was, you know, I don't want to say it. It was basically self-defense. She's not a criminal. She's not a thug. She's not a monster. I know a lot of children say this, but honestly, the best parent I could ask for. She raised all of us on her own. She did all she could. She even worked multiple jobs trying to
Thank you, sir.
Yes, sir.
Is there anyone else?
Good morning, Your Honor.
Good morning.
Julio, M. Hood, H-O-O-D. I just want to say, kind of reiterate what my brother Deontay said. I've watched this woman in my 20-some years of living, you know, do what she has to be with a mother of 4 kids. And, you know, I'm going to try my best not to keep saying the same thing over and over. But time and time again, I've watched her give her life. You know, when I've asked for something, needed help, she never hesitated once to, you know, deny me of the things I wanted or needed. So for her to, you know, whatever happened at night to happen, it's kind of, you know, I guess out of character, so to speak. It's just, again, her last conviction was 20-some years ago, and she hasn't been in trouble since. So that right there alone should tell you that she's not whatever this, you know, the sentence may be, or character she may have been made out to be as far as discharge. And I don't know. It's kind of crazy to me as far as what has transpired when it transpired. I don't know. She's worked hard and continued to have done what she's supposed to, and as far as a civilian and you know, wherever she resided. And I've never seen a woman work as hard as she has to continue living the life she has, regardless of the past charge. So I mean, that's pretty much all I wanted to say. And yeah, I guess that would be it, Your Honor.
Thank you. Well, Ms. Woods, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No.
Smith, anything else?
Nothing additional, Your Honor.
The State of Ohio, Ms. Mulligan?
Your Honor, at the time of the plea, the state's position was to recommend community control as a sanction for this crime. That was in keeping with the victim's wishes in this matter. Obviously, that recommendation was predicated on her cooperation with the process. And so far, she has shown that she is not able to follow directions and the authority of the probation department, and believe that prison is the appropriate.
Thank you. Well, this court has considered the particular facts and circumstances of the offense as they were related to the court. I do not have a pre-sentence report investigation to consider because although the court ordered it for the benefit of the defendant, she failed to appear at the probation department for the purpose of her interview, which was necessary to complete this report. So I don't have the benefit of a report. But I've considered the nature of the offenses, circumstances, and the nature of the offense, I should say, the circumstances. I've considered what's been said by Ms. Smith, the prosecutor. I've considered the statements made by family members who are present. I received a victim impact statement from Mr. Bradford. I've read and considered that. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911. One second. So the factors in 2912, court notes the victim suffered serious physical harm as a result of the conduct involved. A weapon was used. knife. As far as actually making it less serious, she pled to an aggravated assault, which includes provocation as an element, so that doesn't make it less serious because that's a part of the offense for which she pled to and was given consideration for that by the prosecutor with the offer. So recidivism factors, got one prior conviction from over 20 years ago. Does not appear to be any genuine remorse. There's nothing indicating to the court of that. She also violated her bond, and not only testing positive for marijuana and using that while she was on bond, but then she also failed to appear, as alluded to a couple times here, for her pre-sentence report, so she couldn't even report the probation department to get interviewed, which would, his whole sole purpose was to help her. Those are all factors indicating recidivism is more likely. For factors indicating it's less likely, the court will note that the defendant has led a law-abiding life. Basically her entire life, aside from the one incident in Tennessee back 23 years ago. Under 2913B1, the court finds the defendant caused physical harm to a person. And also caused physical harm to a person with a weapon. Those are both factors indicating that override any presumption for prison. In addition, as I've noted multiple times, there's no pre-sentence report, which is a prerequisite for the court to be able to consider community control. Based on that, the court finds prisons consistent with the purposes and principles of sentencing. The defendant is not amenable to any available community control sanctions. You had to, it was 3 days of credit, but that doesn't count the last 2 days, probably, right?
It does not, so it'd be
So it's 5?
Yes.
Therefore, it's a sentence to this court that on count 1, defendant served, amended count 1, defendant served a term in prison of 12 months. She has credit for 5 days she's already served. Count 2 will be dismissed. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another 6 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and the court further orders restitution to Calvin Bradford in the amount of $878.05 for his unpaid medical expenses. Ms. Mulligan, anything else for the record?
Nothing from the state, Your Honor.
Ms. Smith?
Not this time, Your Honor. Thank you, Your Honor. We're present in case State of Ohio versus Brandon R. Swope, case number 25 CR 234. The defendant is present today in court represented by attorney Bill Watson. We are here for purposes of a change of plea as well as sentencing. My understanding is that the defendant intends to plead guilty to count 1 of the indictment, grand theft of a motor vehicle, a felony of the 4th degree. There's no agreement as to sentencing. At the time of sentencing, the state will recommend 12 months consecutive to the sentence that the defendant is presently serving, and the defendant would be free to make his own sentencing recommendation at this time. Thank you.
Thank you. Mr. Watson, does that sound accurate?
Thank you, Your Honor. May it please the court, yes, that's my understanding of this afternoon's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with my client a multitude of times. To be honest, I do believe my client is prepared at this moment to enter a change of plea. He understands that by doing so, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. Mr. Swope, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this afternoon?
Yes, sir.
It was indicated to the court they believe it's your desire to withdraw your previous entered plea of not guilty and plead guilty to the charge and the the indictment.
Yes, sir.
We would then proceed straight to sentencing where there's no agreement between the parties regarding any recommendations. I guess the state has agreed that they're going to recommend no more than 12 months to be served consecutive, but you're free to recommend to the court whatever sentence you believe is the right thing to do.
Yes, sir.
So is that your understanding of the discussions that ultimately took place between your lawyer and the prosecutor and what you want to do here today?
Yes, it is.
Well, before I can accept your plea, I need to make sure you understand everything that's going on here. I need to make sure you understand the rights you're giving up, the penalties you face, what you're pleading guilty to. I know we did this rather recently, but I have to do it again for this case. If you have any questions at any point, you need anything clarified, repeated, let me know that. You want to talk to your lawyer, let me know that as well, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
30.
Are you able to read and write the English language?
Yes, I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you had any drugs or alcohol of any kind?
Other than prescription?
Oh, even prescription. Both, either.
I take 3 prescriptions.
Okay, so what? So it's no illegal drugs?
No.
Just prescribed medication?
Correct.
And what prescribed medication would you have taken within the last 48 hours?
Invega.
Okay.
6 milligrams. I take Toppermate, 200 milligrams. I take clonidine, 2 milligrams, or 0.2 milligrams, or 0.1 milligrams. Sorry.
Anything else?
And I take omeprazole.
Okay.
I don't know the dosage on that.
That's all right.
I'm not sure what the dosage is on that. It's just for heartburn.
That's all right, yeah. Do any of those 4 medications affect your ability to understand or appreciate where you are, what's going on around you, anything like that?
The Invega causes drowsiness and memory. It sometimes affects your memory, but not. I know where I am.
So right now, do you believe that Invega is negatively impacting you in any way, which is affecting your ability to understand me, to appreciate your surroundings, to communicate, anything like that?
No.
Okay. Now, you would have received a copy of this indictment about a month ago, maybe a little less than that. About a month ago. Do you remember getting that?
Yes.
You had a chance to look that over?
Correct.
In that indictment, you are charged with 1 count. And what's alleged here and what you'll be admitting to is on or about November 14th, 2024, as a part of a continuing course of criminal conduct in Lake County and Ashtabula County, Ohio, excuse me, that you did with purpose to deprive Chelsea Thornton and or Shane Thornton, the owners of property being a motor vehicle, that you knowingly obtained or exerted control over that property without the consent of either Chelsea or Shane Thornton, who again were the owners, or anyone else authorized to give consent. It's further alleged that the property involved is a motor vehicle as defined in our revised code, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions about it?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand the rights you're giving up by pleading guilty, and you first of all have a right to have a trial. The trial could be to me as a judge, or I listen to the evidence and make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes.
If we had a trial, the prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of the charge. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able to overcome that presumption and prove you guilty. Do you understand that?
Yes, I understand that.
Now, in regards to that burden of proof, since this is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. That is the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence, the quality of the evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charge beyond any reasonable doubt before you could ever be found guilty at a trial of this charge. Do you understand that?
Yes, I do.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, I do.
Now, in order to try to do that, if we were going to have a trial in this case, the prosecutor would call witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, I do.
You understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, I do.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, I do.
And you further could request the court issue an order if there was somebody out there that you wanted to have come testify that wasn't willing to come in on their own. You can request an order that we call a subpoena, which would force or make them come to court to testify for you and answer your lawyer's questions. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up that right?
Yes.
And I'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, she's now allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own attorney can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
Lastly, if we were to go to trial and you were found guilty of the charge, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor, and we're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by this court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony in the 4th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes, sir.
Do you have any other charges pending against you right now?
In Ashtabula County, I have some misdemeanors.
Just misdemeanor, no other felonies?
Correct.
Okay. I know you're currently serving a sentence out of this court. At the time of sentencing on this new case that we're here for right now, if I impose a prison sentence, I have the discretion to run that prison sentence either concurrent or consecutive with the sentence you're currently serving. Concurrent means you'd serve the sentences at the same time, whereas consecutive means you'd finish the sentence you're currently serving. Once that's complete, then you'd begin to serve and have to complete the sentence in this case. You understand the difference there?
Yes, sir.
Now, if a prison sentence is imposed in this case upon your release from prison, you could be placed on what we refer to as post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that? It's not mandatory. It's up to the parole authority to decide that. I don't have any control over that, though.
Yes, sir.
Now, if you are put on post-release control and you were violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined in this case up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes, sir, I do.
You could also be ordered to pay restitution if that's applicable for any economic loss any victim may have suffered as a result of the conduct. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not mandatory in this case. You are eligible with this offense to be put on community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you would automatically be put on probation? It means it'll be considered by the court if that's what you requested. I'd look at all the information, then I'd make the decision I thought was the right thing to do. Do you understand that?
Yes, sir.
If you're put on community control, it could be up to 5 years. And as judge, I would have the discretion to order a variety of different conditions or rules to follow. One of those rules or conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, sir.
Further, if you are put on probation and you're violating any of the conditions, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including local jail time, or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be anywhere from 6 to 18 months in prison, and it could be consecutive to any other sentence that you may be serving at that time or that you may be getting sentenced to at that time. Do you understand that?
Yes, sir.
Lastly, when we do proceed to the sentencing hearing, you have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend a sentence to court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyers have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir, I do.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with your lawyer?
Yes, sir.
Has your lawyer made any promises to you about what's going to happen at the time of sentencing, which is inducing you to plead guilty?
No, he has not.
Have you been threatened or coerced by anyone to plead guilty?
No, I have not.
Are you entering this plea here today freely and voluntarily?
Yes, I am.
All right, then do you have any questions for me at this point regarding anything we've just discussed? The rights you're giving up, the penalties you face, what you're pleading guilty to?
No, I do not.
Do you need any more time to speak with your lawyer before we go forward with the plea?
No, I do not.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I need you to listen to what she says, because I'll have some follow-up questions for you, all right?
Yes, sir.
That's what.
Thank you, Your Honor. If this case proceeded to trial, the evidence would have shown that on November 14th, 2024, in Perry Township, Lake County, Ohio, Chelsea Thornton drove her vehicle that is registered to her husband, Shane Thornton, to the Dollar General. She parked in the parking lot and went inside the store to do some shopping. She accidentally left her key fob inside the vehicle, and the vehicle was unlocked. The defendant was in the area, entered into the vehicle, and drove the vehicle away from the parking lot, eventually parking the vehicle in Ashtabula County, Ohio. He exited the vehicle and then walked away in Ashtabula County. The vehicle was then located shortly after by Ashtabula City Police Department, where the victims then responded to the scene and took possession of their vehicle. The defendant did not have permission to take this car from either Chelsea or Shane. Thank you.
Thank you. Mr. Swope, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, sir.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then regarding count 1, charging you with grand theft of a motor vehicle, a felony of the 4th degree. What is your plea to that count?
Guilty.
All right, I have in my possession here at this time a document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand the document, that you sign it here in court. My understanding is before I came out here, you had a chance to go over that document with Mr. Watson. Is that correct?
Correct.
Mr. Watson, is that accurate? Did you review this with Mr. Swope, read it over with him, answer his questions?
Yes, Your Honor. I reviewed the written plea of guilty form with my client. He read along with me. He indicated he understood it. He signed it in my presence, and I signed it in the presence of the prosecutor, Your Honor.
Mr. Swope, is that correct?
Yes, sir.
You understand what the document says?
Yes, sir.
Do you have any questions for me about what it says?
No, sir.
Now, it does appear that you signed the document. Did you in fact sign it?
Yes, sir.
Mr. Watson, you witnessed that?
Yes, Your Honor.
Mr. Would you as well?
Yes, Your Honor.
Very well. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, grand theft of a motor vehicle, a felony of the 4th degree in violation of 2913.02A1. As far as the plea goes, Ms. Wood, is there anything else I need to address or that was omitted that needs to be addressed?
No, Your Honor.
Mr. Watson?
No, Your Honor.
Okay, all right, give me 1 second, please. Mr. Watson, any reason not to proceed to sentencing?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll try to keep it brief. I know this case was previously set, I believe, by way of information, what happened, Your Honor, was that my client had indicated he wanted a plea. I was going to be on vacation that week. My client had indicated that he wanted it as soon as possible, understanding that I'd be gone. So I know it was set on the week that I was gone, and I know he didn't ultimately take a plea that day. Your Honor, I know it may come across both to the prosecutor and to this court that my client may be trying to play games and fooling around. Truth be told, I don't think that is at all. Now, truthfully, this has been an extremely challenging plea and case to work on, not because of the case itself. It's just an F4. It's pretty straightforward. But I firmly believe Mr. Swope has some legitimate problems, mental health problems and drug problems. And I know I brought this up at the sentencing at the last case. I sincerely believe Mr. Swope when he tells me that he wants help. Now, I know this court gave him a sentence on the last case. I know this court has a lot of discretion today as to what it can do going forward. I don't exactly know how much time he has left, but I think with the credit for time served, he's got approximately 5.5 to 6 months in, leaving approximately 5.5 months left on that 11-month sentence. I'm going to respectfully ask the court to consider running a concurrent sentence on this matter. I know this court may feel Mr. Swope doesn't deserve it, that he's got lots of prior record, that he's, again, maybe played games with the court, but I sincerely believe that Mr. Swope does have some mental health issues. He's claimed to me at the original change of plea, he got confused with the attorney that was here, and I'm not trying to throw Ms. Smith under the bus here because she's a very competent attorney. I just think Mr. Swope, because I wasn't there, he was used to dealing with me, may have gotten a little confused. That's why that one didn't go forward. He's been upset as of late because he really had his heart set on going to treatment. Again, I know the court has a lot of discretion. I'm going to respectfully ask the court to consider crafting a sentence. Hopefully, it'll consider running something concurrently, maybe with a little bit of time after the roughly 5 months he has left. But I told Mr. Swope that even when his cases are over with, the day he gets out of prison, if he still wants help and he still has problems, he can still reach out to the public defender's office. He doesn't have to have an active case to want to get help. He can still reach out to me. I can work with Erin Mayer. I know the court's well aware of her and Mr. Swope's matter to try to get him some help if he's sincere with what he says. I believe he is. You'll hear from him in just a second, Your Honor, but I'm hoping the court takes these factors into consideration. Thank you, Your Honor.
Thank you. Mr. Swope, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, sir. Thank you, Your Honor. So I have what's called psychoschizoaffective disorder, and I have multiple personality disorders, so it makes it hard sometimes for me to have the same train of thought. They waited till after, they actually waited to put me on my Invega the day after I got sentencing, so I didn't think it was fair, I'm not trying to shift blame or anything. I didn't think it was fair for me, when you asked me like my behavioral problems, I had put in multiple kites to mental health and to the health, to the prescribers at the jail for them to place me. I had prescriptions when I came into the jail for Invega and for clonidine, and I had 2 other prescriptions that I don't remember what they were because my mother usually handles my prescriptions for my mental health that I came into the jail with, including methadone, that they took me off of when I came into the jail. So my behavioral problems, part of them, not saying all of them, but part of them was due to them taking me off of my prescriptions when I came into the jail. I'm not taking, I take responsibility for what I did, but I had been trying to reach out to mental health and see the prescriber to get placed on my medications so that I didn't have my behavioral problems. And then also I had been working with the ladies Karen and Kim, seeing them weekly talking to them about my PTSD and my behavioral problems. I had been doing there's a activity called Life Beyond Prison and Parole on the tablet. I don't know if you're aware of what it is. It's called Life Beyond Prison and Parole. It's a program that you have to log into. It's verifiable. You can actually check in if you want after sentencing. You can check in. I have to sign in with my inmate name and number. You can verify it. That's why, it left a sour taste in my mouth that the prosecutor said that I wasn't doing anything with my time at the institution, because it's documented that I go to AA, it's documented that I go to Bible study, it's documented that I go to church, it's documented that I've done these programs, it's documented that I've done these things. I'm not doing anything with my time. I'm doing productive things with my time to show that I am trying to recover, that I am asking for help. I've put in over dozens of kites to mental health, and all the response is that you're on the waiting list. Well, how long does it take for me to get the help that I've been asking for? And in the meantime, I'm having behavioral problems because I'm not on the medications that I've been asking for, that I came in with prescriptions for from the street, that they took me off of my medications, and then they're telling me to behave. I have mental diagnoses that you guys are telling me to behave, but you took me off of my medications, and then you're telling me to sit and behave, and then I get put in the hole, and they're like, well, why can't you behave? Well, why can't I see a doctor? You know what I mean? I take responsibility for my actions, but I'm also asking for help, and I'm not getting any help, but I'm being consequenced at the same time. So I'm being held to a double standard because I'm asking for help, but I'm also being consequenced. So I'm asking for help. I'm trying to help myself, but I can only do so many things. So I'm meeting with the counselors. I'm taking certain steps. I'm taking all the steps that I can, and I'm trying to get the medications. I'm trying to work the books. I'm asking for the treatment, and then because I feel because I had these warrants in Ashtabula, I automatically don't qualify for the Alpha House. I was so set on the Alpha House. That crushed me. I was so set on going to Alpha House. I would have loved to go to Alpha House because it's faith-based, and I'm huge on faith. And it hurt me when you said did God tell you to do the pipes with the flooding? I didn't mean for that to happen. I didn't mean for that to happen. If I could take that back, I could, but I can't. I took responsibility for it because I'm a man, and that's what men do. We take responsibility for our actions, and I did that. I took accountability for myself, and I asked for some leniency. I took responsibility for what I did. Just like now, I'm taking accountability for what I did, and I'm asking for a little bit of mercy, and I'm asking for concurrent time because I'm taking accountability for what I did. And I need help. Thank you.
Thank you. Mr. Watts, anything else on behalf of the defendant?
Nothing further, Your Honor.
For the state of Ohio?
Thank you, Your Honor. On behalf of the state of Ohio, my recommendation is for 12 months prison consecutive to the prison sentence that he is currently serving in case number 24 CR 1386. This was a case where the defendant entered into the victim's vehicle. The victim forgot that she had left the key fob inside her vehicle. It was unlocked, and the defendant drove the car all the way to Ashtabula before he parked it and exited. Thankfully, there was nothing taken from the vehicle, and it was not damaged, and the victims do not have any outstanding restitution. However, they still had to deal with a time period of inconvenience and alarm that an unknown person had entered into the vehicle and taken it. At the time, the victims did have the Ford Pass app, which is a GPS location app on the phone, so the victims were able to see exactly where the car was traveling and able to alert the police, which enabled the Ashtabula City Police Department to swiftly and quickly recover the vehicle. The defendant does have a history of criminal convictions. He's been on community control sanctions before. He's violated, and he's been sent to prison on 3 separate cases, and then most recently by this court in case number 24 CR 1386. The defendant does acknowledge that he has substance abuse issues or mental health issues. However, after his time in prison, there's been limited or minimal engagement in any services to address any substance abuse or mental health issues. So the state is recommending 12 months consecutive. The state's recommendation is that this sentence be run consecutive to the sentence that he's currently serving. In order to protect the public, we do not believe that this would be disproportionate, and his criminal history demonstrates that consecutive sentences would be appropriate in this matter. Thank you.
Thank you. Well, this court has considered the pre-sentence report investigation that was completed in the other case in regards to all the background information involving the defendant. I've considered the facts and circumstances of this case, the nature of the case, as they were related to the court during the plea. I've considered everything that's been said here in court. Hang on one second. I've considered everything that's been said here in court by Mr. Watson, the defendant himself, the prosecutor, the recommendations from the parties. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, factually, there does not appear anything that stands out which would indicate the conduct is more or less serious. As for recidivism factors, many of these are present. The defendant committed the offense while on probation in Painesville Municipal Courts. He's got a very lengthy history of criminal convictions. He's previously served multiple prison sentences before. Drug abuse problem that relates to the offense, and he hasn't addressed it. Again, there were multiple disciplinary issues while in jail. No factors indicate recidivism is less likely. Under 29-29-13B1, the court finds the defendant previously served a prison sentence which overrides any presumption for probation. The court finds prisons consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanctions. Therefore, it will be the sentence of this court. Defendant serve a term in prison of 12 months. It's a completely separate offense from what he's previously sentenced for. Different victims, different conduct, and it deserves separate punishment. The court's going to order that it be served consecutive to the sentence imposed in 24 CR 1386. Consecutive service is necessary to protect the public from future crime and to punish the offender. Those sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. There's no credit on this case. I need to advise you upon your release from prison, you could be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit. Well, in this case, another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's order to pay out costs. Is there anything else for the record, Ms. Wood?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Thank you, Your Honor. Your Honor, we're here this afternoon in case kept in the state of Ohio. This is Alan Servar, case number 24CR001179. We were last here on April 3rd, at which time the defendant entered a written and oral plea of guilty to one count of felonious assault, felony of the second degree in violation of revised code section 2903.11A1. The case was then referred for a pre-sentence report, an investigation, an updated psychological, and a victim impact statement. Those have been completed, and we are here today for purposes of sentencing. Defendant is present today with his counsel, Mr. Chad Mulkey.
Smoke, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, he's 50 years old. He's single. He has no children. I did see in his report, he confirmed that he did get an associate's degree in culinary arts, but that was a long time ago, and since then he had been working in construction and roofing. Found that to be more to his liking. He'd like to get back into that line of work. Your Honor, he understands that he has to deal with the consequences of this case here. The serious injury occurred to his mother. There's no denying that. He knows that is what happened. Going back to his history, he has significant drug use going back to the age of 14 with marijuana, and then from there cocaine, and then heroin, particularly opiates seems to be his drug of choice. Most recently, he acknowledges that he has a problem with those. He was trying to get off them, but that problem has not yet seemed to have been dealt with. So he would like treatment as part of his sentence, Your Honor. I'd explained to him the realistic nature of the charge and the consequences in terms of a prison sentence. He knows that may be in his future in light of the circumstance of this case, Your Honor. So we would just ask the court to consider a lower side of a prison sentence if the court deems that is appropriate, citing his lack of criminal history. He would like to someday, if possible, repair his relationship with his mother, get the treatment that he needs, and again, based on his age of being 50 and his lack of history, and then go from that to a felonious assault of his family member, it just seems that it was something that would not be repeated again, certainly not not in any sort of a consistent pattern or anything like that, Your Honor. So we would just ask the court to consider minimal incarceration time followed by appropriate treatment such as NeoCap, Your Honor. Thank you.
Thank you. Mr. Serrar, you have the right to address the court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
I've already spoke with my mom. She knows, she's already even told the detectives that this would never happen. I was going to the methadone clinic. This wasn't drug-induced. I was going to the methadone clinic. I was getting 140 milligrams of methadone, and I figured out a heavy narcotic. And I was flunking every drug test, and they didn't say anything for 8 months. So I had this one morning, I said, I'm not even doing the methadone anymore. Stopped cold turkey. Didn't sleep for 10 days. Mental police picked me up, running up and down the street. They took me to an intensive care mental hospital for 7 days, where the doctor even said I wasn't ready. This is all video evidence of me not sleeping. And then 2 days after I left the mental hospital, this happened. And even when I was at this jail, I'm on camera not sleeping. This wasn't drug-induced. This was from lack of sleep-induced. I would never, all the years I've been, I would never harm anybody, let alone my mom. And she even told the police that. She's like, she knows this isn't me. And I mean, I'm at a loss of words. I'm heartbroken. I mean, like I said, I mean, you've seen a lot of people here, Your Honor. You have high power perception. You'd have to make your own judgment, but I'm heartbroken over this.
Thank you. Mr. Mulkey, anything else you care to say?
No, Your Honor, not at this time. Thank you.
Ms. Linden for the state of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in Chambers Estate, is recommending a prison term. As I stated, there aren't many cases these days that when, because I've been doing this for as long as I have, that I actually look at a photo and gasp, and I did here. This is, and I know that the on-call prosecutor that was involved in this as well, similar reaction. It is horrific to see the injuries that this woman, who was 80 at the time, sustained. There's one thing to have a black eye, and there's another one to have a black eye that's so swollen and out that it almost looks like the eyes are bulging out. She had brain bleed. She had multiple broken bones as a result of this. And as I stated, when you listen to the 911 call, I know the defendant says he only hit her 4 times, but you hear 5 distinct thuds. He does talk about grabbing her, squeezing her, and taking her to the ground. And she remembers some part of it, and she remembers arguing with him. But looking at that, looking at the fact that she was in critical condition, she was intubated and she was in the hospital for so long, this is more than what I normally would see, and especially looking at the factors that we have to look at under 2912B, C, D, and E. She's 8 years old. Their relationship is his mother. She had serious injuries, so she had physical harm and psychological harm as a result of this. Looking at the fact that he doesn't really have much of a history, he does have the 2 prior OVIs and a drug case, but drugs seem to be a really significant issue for the defendant, and it doesn't seem as if even the treatment that he's had, if there are real mental health issues or if it's drug issues, he went in for treatment for St. Vincent Charity Hospital, didn't remain sober, did Signature Health, had medically assisted treatment there, didn't continue with the treatment. Through the methadone clinic, he did all right for a while, but then he refused medication and he's continued to use drugs throughout. And I don't remember the last time that I have seen something that says that there is a serious or severe disorder, opioid use disorder severe, stimulant use or use disorder severe, cannabis use disorder severe. And looking at that and looking at his history, he's been using drugs for a really long time, and it appears that his drug use causes him to have these types of episodes. And so in looking at protecting the victim in this manner and protecting the community at large, and looking at there's been some aggression that he's had within the jail. I know that a number of the incidents that he had were prior to him going to North Coast, but blaming stopping his medication, that's not what it is. There are serious issues that need to be addressed, and a prison term is definitely appropriate here. He does have 216 days of credit for time served, and we would ask for the forfeiture of all the marijuana, the foil package, the plastic bag, the metal can, the rolled cigarettes, rolling papers in the glass jar. But I just don't see any way that, based on the injuries here and based on the severity of this offense, that community control would be appropriate. Perhaps at some time at a later date when the defendant understands that there are serious consequences for his actions, maybe at that point in time, that's something to consider down the line, but not at this point in time. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation. Competency evaluation that was earlier prepared in this case, the victim impact statement. I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court by the defendant, his lawyer, the prosecutor, the recommendations from the parties. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 2911. One second, please. I've also considered the factors under 29 and 2912 that indicate the conduct is more or less serious, as well as recidivism factors. As far as the seriousness factors, the court finds the victim in this case suffered serious physical harm as well as psychological harm. And I recognize serious physical harm as an element of the offense, but the serious physical harm caused by the defendant and suffered by the victim in this case is much, much, much greater than what we normally see in a felonious assault case that deals with serious physical harm. I mean, serious physical harm is such a wide range of harm, quite frankly. You can have somebody that gets hit and has a scar. That's serious physical harm. The nature of the serious physical harm in this particular case is horrific, quite frankly. And then this injury and harm that's suffered by the victim is certainly exacerbated by her age, being 80 years of age. The relationship with the victim facilitates the offense. That makes it much more serious, being his own mother, 80-year-old mother that he did this to. There's no factors indicating it's less serious. As for recidivism factors, the court will note that there's a couple of OVI convictions. That's it on his record. There is a drug abuse problem. The defendant, it's gone untreated. A long, long drug abuse problem that's just gone untreated. As for factors indicating recidivism is less likely, the court finds the defendant doesn't have any prior convictions, aside from the OVIs, misdemeanor OVIs, there's nothing else. Law-abiding life, basically his entire life, aside from the traffic stuff. This is a felony in the second degree. There's no way the court can make a finding at this point that factors indicating a defense is less serious outweigh the factors indicating it's more serious. Prison's consistent with the purposes and principles of sentencing, and this type of conduct and the harm caused by the defendant's conduct just can't be ignored. It can't be. Prison is consistent with the purposes and principles of sentencing. The defendant's not amenable to available community control sanctions. Therefore, by the sentence of this court, the defendant served an indefinite prison term of a minimum of 4 years, maximum of 6 years. He has credit for 216 days he's already served. I need to advise you upon your release from prison, you will be placed on post-release control for at least 18 months, could be up to 3 years. While in post-release control, if you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence At this time, defendants order to pay all costs incurred in this action. Further need to advise you that the indefinite sentence that I just imposed, there is a presumption that you will be released after you have served the minimum sentence. That is not guaranteed, that based on your conduct in prison, but a presumption that you will be released after you've served the 4 years. Again, that could be rebutted by the Department of Rehabilitation and Correction. If at a hearing they are able to establish that while you are in prison, you basically didn't follow the rules, you committed institutional violations, you're not sufficiently rehabilitated, you still pose a threat to the community or to others. If that determination is made, then you would not be released at the, and you have the right to be there at that hearing. If they can only do that if there's a hearing and you have the right to be there. But if they make that decision, then you would not be released. They would set another date for you to be released, and there'd be a presumption that you'd be released at that other date. That presumption can again be rebutted if again they prove that you are still committing violations, not behaving yourself, not rehabilitated, still pose a threat. Under no circumstances, however, can you be kept in beyond the maximum sentence. Even if you misbehave the whole time you're there, they have to release you after you've served the maximum sentence. I further need to advise you that while you are in prison, you are entitled to earn good time credit. And there is a presumption, and if the prison officials, it's anywhere from 5 to 15%, if the prison officials find that you are entitled to that, they would notify the court. There's a presumption that I would have to approve that good time credit. You only get it if the court approves it. There's a presumption that it should be approved. If I wanted to disapprove it, you would have the right to have a hearing here in court before that could be disapproved. Otherwise, it would have to be approved. I think that covers everything. Is there anything else? Count 2 will be dismissed. Is there anything else for the record, Ms. Linden?
And just the forfeiture that we talked about, Your Honor, at the time of the change of plea.
That's all just drug paraphernalia?
Yes.
Well, any type of drug paraphernalia and drugs would be forfeited.
Thank you, Your Honor.
Mr. Mulkey, anything else?
Your Honor, I didn't hear of it, so I'll just bring it up. Is there any restitution on this?
I don't believe. Let me check the victim impact statement again.
I was not advised maybe, but if there's something in the victim
I'll
impact
check right
statement.
now. I had several today, and I want to make sure I don't miss it. But no restitution. None that was provided in the victim impact statement, and nothing presented by the state.
No, Your Honor.
Thank you, Judge. Just double checking.
Okay, thank you.
All rise.